Today I'm going to be talking about the Form I-9 and government enforcement of this particular form. All employers are required to get the Form I-9 completed for their employees in order to show that they're entitled to work in the United States. Even U.S. citizens are required to complete this form. Now what's happening currently is that the government has a stepped-up enforcement of I-9 forms. And what they're doing is they're going around the country and they're visiting employers. In some cases they're conducting raids in employer facilities, coming in to examine the Form I-9. If it's determined that the I-9 forms were not properly completed, or if the employer has a number of illegal or unauthorized workers at their company or at their business, then the government can go after the employer for sanctions. Now, the purpose of today's discussion is to talk about what employers can do to avoid these huge civil sanctions that they've been paying. There have been many news reports about employers paying tens of thousands and in many cases hundreds of thousands, or in certain cases over $1 million in civil penalty sanctions for having I-9 forms done incorrectly or for having unauthorized workers as part of the workforce. Now what happens is the government comes out on their enforcement action, they review the I-9s, and they'll suggest a civil penalty. Now I've heard from these government workers who conduct such raids or investigations that they're really looking for criminal penalties. They're trying to convert what should be civil sanctions into criminal penalties. So today's discussion concerns only the civil penalties, because if the government is threatening criminal action, then that could be why some companies are paying hundreds of thousands of dollars in fines in order to avoid criminal charges. On the other hand, where the government has not threatened criminal charges at all, but are going after a huge civil fine, then it certainly benefits the employer to try to fight this huge civil fine. And the way the process works is the government can institute administrative law proceedings, and the case ends up being litigated just like any other type of civil litigation. And from my experience in handling these cases, many times the government will settle. And sometimes it takes a while, sometimes you're required to do discovery, to do depositions, but eventually the government has typically been inclined to settle, and certainly the administrative law judge encourages the parties to settle the case. So instead of being so quick to pay huge penalties, an employer should give serious thought to contesting those penalties and going through this civil litigation process before the administrative law judge in order to find discovery, find out what evidence the government has, and then try to settle for something less than the huge amount of money that the government may be asking for. And we've helped all types of companies in these sorts of cases. We represented, for example, a Chinese restaurant chain where the government went into their various restaurants and arrested a bunch of their workers. And we were able to negotiate a very reasonable civil penalty for them, much less than what they could have paid early on in the case. So it's certainly worthwhile in a case where there's no threat of criminal charges to dispute the civil penalties and to litigate at least for a little while in an effort to try to get the government to compromise.